Fork Road electric pole number was when I was in between moving in 2006 and didn't know the physical address of my residence. Even then, I listed that I was running from Laurel Hill. I've always maintained I did not base my residency upon the properties I own that border Laurel Hill, Union, and Jefferson District. I hope this helps, period. Well, I shaped that into an affidavit. I emailed it to the doctor. He emailed me back some corrections. About where Harts is. The Harts is not actually in the Laurel Hill district, it's in a different district. And then it just so happened that it was on a Wednesday, last Wednesday, and my wife was shopping at Southridge, and I got an email from Dr. Vance saying I don't have a notary here at the clinic. And so my wife got a trip to Harts. She drove from Southridge down the corridor to Chapmanville and got off and drove up Harts to the clinic and took, my dealings with Dr. Vance have been by email, but I have no reason to believe that if he called to testify, he'd say anything other than what he said in his emails and in an affidavit that he reviewed twice and sent back to me for revision before he signed it. Now, will that stand up under cross-examination? I don't know. I assume the man's entitled to that opportunity.
Let me ask you one more question, Mr. Payton. Do you concede that Phoebe Harless does reside within Magisterial District 3?
Unquestionably, and she did at the time she filed her candidacy papers, which as I understand now under the law is adopted by the legislature. See, there was a case, actually I think one of the cases that we cited in response dealt with when does a person have to be a resident, and the Supreme Court went so far as to say in one case, or at least imply, that residency at the time you were elected to the office, actually the general election certified, would be good enough. The legislature clearly stated last year in the findings upon which they based their direction that we want to eliminate any uncertainty, and there has been uncertainty about when a person needs to be a resident. Therefore, it will be the day they file their certificate of candidacy, period. Is that way you understand, Mike? Because what happened, there was another candidate for county clerk, for county commission in Lincoln County in 2008 who clearly lived in the same magisterial district as Commissioner McCain, Carroll district. But I think said, well, if I win the election, I'll move. Well, he didn't get the most votes, so that never came up. But the legislature straightened out. So she's clearly there, was there on the day that matters. Right, Phoebe?
That's a sensible way of looking at it, certainly, because people move all the time. We have jurors that start out here and they move away, and sometimes you have difficulty keeping track of them. And certainly with candidates, it seems to me that the best way to look at it is to see where that candidate resided and where the candidate was domiciled on the date the certificate of candidacy was filed. And I think that that's clear from the current case law. That's the question before the court, and I can't ascertain from Dr. Vance's affidavit where in the world he lived for certain on the day he filed his candidacy papers. And you can't help me with that.
No, sir, I can't. All I can do is repeat what the doctor gave me in the email, which I sent to him, which he sent back to me, which is his statement that he clearly he owned this property, which is in Jefferson, Texas. If you look at the face of the deed, the face of the deed says it lies on the waters of Hennis Branch and Mud River. Well, that is a fact. That's what the face of that deed says. He clearly owned it. He bought it in 2001. He was already on the county commission at that time. does the acquisition of that property, or the fact there's a residence on there where he made it part of the time, and get back to District 5, another time is 2, where he transacts his business, gets his mail, does his voting. Does that defeat the fact that once his domicile was established when he ran the first time, that mere temporary residence outside of the district destroys domicile? The Supreme Court seems to indicate no. But that's, those, I believe, are questions best answered by Dr. Vance under some fairly direct examinations and cross-examinations.
Thank you very much, Mr.
You're
Payne.
welcome, Your
Let
Honor.
me hear from Mr. Carey now.
Well, I find it a little frustrating that Mr. Payton is asking the court to delay once again ruling on this issue. This is a question of fact to be decided by the court. It is also a question which is, I believe, takes precedence over the election contest. Because if we do it the way Mr. Payton wants to do it, which is wait until we have the trial in the election contest, then Mr. Ramey is going to be forced to attend at least 3, and probably now that there's been over 100 witnesses identified, they've grown from 15 to 18 to 49 on the other side. I'm not knowing what all 49 are going to say. I just simply list those people that I think may be relevant. So we're now over 100, and obviously we're going to go through 5 days of hearing. All for naught if Ms. Harless is unqualified by the Constitution of the state of West Virginia to sit. And the court has identified the issue. What was his residence? What was his domicile as of the time of his election in 2006? Now what we have is a statement sworn to under oath by Dr. Vance that his residence was 12445. And I think Mr. Payton conceded today that that residence is identified as 12445 Lower Fork Road is within Magisterial District 3. So the question then becomes, does that sworn statement under oath establish his residence for the purposes of this hearing? I believe it does. Now, even though Ms. Payton was given the opportunity to drive to Harts to have him sign the affidavit, she apparently didn't take a subpoena with him and have him here today, so he can testify and be subject to cross-examination. But what he has given us is nothing less than an obfuscation, convoluted statement that he had as many as 2 and perhaps 4 residences sometime in the last 15 years, which he says are in Laurel Hill District, without once giving us an address. Not a single address. And more importantly, he doesn't say where he lived in what time periods at these unspecified addresses. Nor does he provide any corroboration, which the Supreme Court has said is necessary in making this determination. If you're going to contend you have 2 residences, but establishing one as the domicile, then you have to show where you predominantly spend your time. What activities do you do there? He didn't submit a single lease, a single deed, a single utility bill, nothing to suggest that in the primary and general election of 2006, he lived anywhere else other than 12445 Lower Fork Road. Now, notably, we only have in the record now 2 documents which give us his address in the relevant time period. We have his Exhibit 1, which is his certificate announcement, which he swore to under oath was his residence at the time of the filing for election. And we also have a document that was returned, as testified by Alan Holder, in May 19, 2006, for Charles Vance, listing 12445 Lower Fork Road as the residence owned by him. And that was returned on May 19, 2006. Again, another indication that that's his residence. On top of that, Your Honor, we have the prior testimony from Larry Barker that is within Magisterial District